My name is Frank Iacobucci. I'm an ex-law professor, an ex-deputy minister of justice, an ex-chief justice of the federal court, and an ex-justice of the Supreme Court of Canada in the same-sex area. I was the deputy minister at the time. The governments, there was the Mulroney government. My ministers of justice were first John Crosby from Newfoundland, brilliant, one of the most able people I've ever met, and Raina Tishin from Saskatchewan. A wonderful, wonderful human being, and an insightful politician, extremely intelligent also. They were clearly in favor of amending the Human Rights Code to include sexual orientation. But politically, that was not acceptable at the time. But there's an area, the sexual orientation cases, were an outstanding example of where the court proclaimed that the equality protections of Section 15 did reach out and include sexual orientation. I will say, I've never said this publicly before, but I will say, I'm now safely away from the bench, to say that the cases that I participated in and wrote with Justice Corey in a number of cases that you have referred to, Egan and M&H and Vreen, were the courts in many ways leading the country. Not because they were political decisions, they had a policy implication, of course, but they were based on the law, as we saw, based on the analyses that we saw. And I would stand behind them and say, yes, they were the right role of the court to perform. And I believe it's something that I carry with me as very not only proud of my colleagues, lawyers involved, the gay community who were involved, but also, I have to say, I'm honored by and privileged by the small role I had in recognizing the importance of that subject and indeed moving our country toward an acceptance of those legitimate interests to have Section 15 protect those people from the gay community. That protection started well before the Charter. Again, one of the key players was Pierre Elliott Trudeau when he was Minister of Justice. He brought about the amendments to the Criminal Code to eliminate the so-called the buggery offense, saying that that famous phrase, the state has no place in the bedrooms of the nation. That was in the beginning of a series of events. There was another event ahead of that. And indeed, the legislature of Quebec was the first to introduce sexual orientation into its provincial Human Rights Act. But the Charter didn't have an express reference to it. The court interpreted Section 15 to say that it was an analogous ground under Section 15.